Who's the most recent recipient of the Judge John J. Parker Memorial Award? You'll find out. Coming up next on Carolina People. Good morning. Welcome to Carolina People. This morning we're at the Fox 43 studio. We're focused on the amazing life of an amazing individual, Robinson Oscar Everett. Good morning, Dad.
Great to be back with you.
Thanks for coming back. It was so great to be with you yesterday and to get in a little bit of your life, a little bit of your mom's life, your dad's life, obviously to highlight the Shaw v. Reno and the kickoff of the battles against racial gerrymanders, and obviously to talk a little bit about, we began to highlight your teaching there at Duke Law School, and I think that teaching brought up a little bit of part of the reason why you'd gone after and decided that the racial gerrymanders in North Carolina were wrong. I think I read in an article in the Raleigh News and Observer when you were recognized as the Tar Heel of the Week that it was absurd what was being done. I could not reconcile it with cases I was teaching in law school, particularly ones dealing with race neutrality and jury selection. Will you share with the viewers a little bit about why some of those cases really mattered and how that impacted your thinking?
Well, the Supreme Court had ruled in various cases that peremptory challenges, that is, challenges that are given to jurors, where you can challenge a juror, those challenges should not be exercised on the basis of race. You shouldn't be able to challenge someone because he or she is black or white, nor should you be able to challenge them because they're male or female, for that matter. But the idea is to protect the important right of service on a jury and the important right of a party to a trial to have juries that are not racially gerrymandered or racially selected. And so when I saw the redistricting plan in North Carolina, congressional redistricting plan in 1992, when it was very obvious that it was racially gerrymandered, I said, this is very strange. They will protect the right to jury service, but meanwhile the right of voters to vote without regard to race is being tanked, is being thrown away, disregarded. So that belief that the premise was being violated, the fundamental principle was being violated, was what motivated me to try to do something about it.
So the idea that you couldn't use race for the second most important right you have as a citizen, the right to be on a jury.
Sure.
But you could, and the alternative, use it for the most important right you have as a citizen, the right to vote.
Didn't make sense to me.
Yeah.
And I still don't think it makes sense. The Supreme Court, in some of the later cases, has taken a position that is a little disappointing to me. They say that if redistricting is done for predominantly racial motive, then it is unconstitutional. But it's got to be predominantly racial. Now, that gets into some interesting wordplay. For example, the voting record of African Americans has traditionally been very heavily weighted toward Democrats. And so, in fact, in some instances as high as 85 and 90%, although that's changing. But suppose a district is created using the computer, which is predominantly African American, and the district is obviously created with that purpose. But instead of admitting that it's racial, the legislature says, the members of the legislature that drew the plan say, oh no, this is predominantly political. We didn't choose these people because they were African Americans. We chose them because they predominantly voted Democratic. And the Supreme Court has seemed to say that if the racial motive is concealed in that manner, then the result is permissible. To me, that gives too much of a loophole. But anyway, that's the way the court has done it. As a result, in North Carolina at least, you probably can do better attacking redistricting or reapportionment plans under the state constitution than you can under the federal constitution. So we've got some strange things going on. But at least the Supreme Court has said, if it is predominantly racial, then it's unconstitutional.
You know, that same article in the editorial of the week, Joe Neff's piece in the Raleigh News Observer, talks about you adhering to the notion of the colorblind society and really pursuing that. He then talks about Everett's 10 years as chief judge on the Court of Military Appeals, essentially the U.S. or the Supreme Court for U.S. military, helped him arrive at this position. Analogous to the Supreme Court, the civilian court hears final appeals from courts martial. But then he goes on to say the military is pretty well established a colorblind society where things are done on merit without the quota system. Can you share with the viewers how he got that perception in talking to you, or how you believe he did?
Well, one of the things that motivated me in the redistricting litigation was that it seemed you could put into place plans that were racially neutral. And one of the best examples of that is the military. In 1947, when Harry Truman basically integrated the armed forces and tried to take race out of the picture, people said it wouldn't work, but it has. And the military, I think, do the best job of all in being colorblind. I'm sure there's some discrimination in particular instances, but their policies are very clear. No racial discrimination. Now, in addition, no sexual discrimination. They've tried to eliminate that as well. And so I think the military has, in many instances, given some fine examples for the way things should be done. The Supreme Court has referred to the military as a separate society, and in many ways it is. But there's some aspects of that separate society which make very good sense indeed, and which are beacons for civilian society.
Joe Neff also points out a former student of yours, a Duke Law graduate, the former Speaker of the House, North Carolina Speaker of the House, Dan Blue, who went on to say, obviously speaks warmly of you as a professor, still using a nickname common among Duke Law students, quote, "In an ideal setting, what Robbio talks about is a good thing that I agree with, but we don't live in an ideal world." That's Dan Blue, the former Speaker of the House there in North Carolina. What about that aspect? I mean, is it because you don't live in an ideal world that you therefore don't pursue ideal goals? Or, I mean, what do you think he's referring to directly?
Well, I respect Dan Blue a great deal. He's a former student, and I'm very fond of him. But I think he's wrong to say that, it isn't an ideal society. People do things because of race or gender or ethnicity. Because they do it, it's not worth the trouble to try to change things. I think what you have to do is always keep an ideal in sight and strive for it. It may be very difficult to attain, but that's not a reason to not try for it. So basically what he was saying was that you couldn't avoid racial gerrymandering in our society, and therefore why bother? And I disagree with that. I think maybe you find it's very difficult to avoid. Maybe you won't be able to avoid it, but at least try. And I think there are a lot of things in life that you have to at least try to do, even recognizing that there may be an uphill battle.
Absolutely. Yeah, talking a little bit about that piece of your 10 years of service as Chief Judge of the U.S. Court of Military Appeals, now the Court of Appeals for the Armed Forces, is a good segue. When did you first get active in the military?
I enlisted in the Air Force Reserve in 1950, soon after I got out of law school. and later I applied to be a JAG and was commissioned as an Air Force First Lieutenant, and then went on active duty. That was right at the end of the year, the school year, when I'd been teaching at Duke. And that basically terminated my service as a teacher for quite a while, and instead put me in Air Force uniform. And I went out to West Texas at a base out there. It was rather interesting. The Uniform Code of Military Justice, which is the statute that governs courts-martial, had come into play into effect in May of 1951. And I went on active duty in August of 51. And for some reason, they did not send me to a training program. Some of the other JAGs were sent, but I wasn't. So I was sent out to West Texas to learn OJT, on-the-job training. And what an interesting situation that was, because it was a new law that had just taken effect, and nobody really fully understood it. So that was my first contact with military justice, and in a sense with the military, because I had not been on active duty before for any extended period of time. And then I served on active duty and was ultimately released. I served a little more than a couple of years during the Korean War, and really loved it in many ways. But I decided I'd go back to civilian life. On the other hand, I later decided that I would stay in the reserve, and did so for a total of 28 years, active duty and reserve time. So in my reserve assignments, I kept in touch with the military and military justice. Also, I took a position. It was pure coincidence that I was offered it, but I took a position as a commissioner of the Court of Military Appeals. Now, that court had been created in 1951 as part of the Uniform Code of Military Justice. It provided civilian review of courts-martial for the very first time. Up to that time, you have the military conducting a trial, and the Judge Advocate General would look at it in the particular service, and that would be the end of the road. The president could give a pardon or something of that sort, but basically there was no no civilian judicial review. And Congress thought that it was important to have that, and to have a review that would be by civilians, uniform for all the services. It would be the same type of review. And so this court had come into being. And I went on the staff as a commissioner, which meant that I was a principal assistant for one of the judges. There were 3 judges. Interestingly, each of them had been personally interviewed by Harry Truman before he appointed them. I don't think anybody has done that since then.
Yeah.
And he would nominate them, and then, of course, the Senate had to act on the nomination. And it was a fascinating court to work with. There were 3 judges, one who had a background in each of the armed forces.
Oh.
And the one I was working with had an Air Force background. In fact, he'd been on active duty as, he was a reservist. He was on active duty as a bird colonel at the very time that he was appointed to the court. And so it was a fascinating place where I learned a lot about military justice. And I decided that it would be interesting to write this up, put it into a book that not only lawyers but laypersons could read and understand. So in 1956, I was able to get published a book called Military Justice in the Armed Forces of the United States. And that book had, I hope, simple, understandable text and a lot of legal stuff and footnotes, so that a lawyer could read it and get from the footnotes some of the technical stuff and other people could read it and, understand what it was about.
Yeah. Did you have many book signings with that, Dad? When you
No.
were around? Not too many books.
No, nobody seemed to be interested in having a book signed.
Well, we could rehash that. Bet we could check with Mickey Spillane and see what we could do about that. He'd give you some pointers.
Well, Mickey's books were selling pretty well at that time. I still remember I had the jury. You probably talked to him about some of those books. But in any event, I did get a book out, and I found getting it published was probably harder than getting it written in some respects. But after that book, and this is apropos of your question about contact with the military, after that book, I, in addition to staying in the reserve as a JAG, did a few cases where I would represent people, like in a court-martial or something. And I was active later in the American Bar Association. I was a member of and later chair of their military law committee. So I had a lot of contact that way. Mm-hmm. So that kept up until 1980 when President Carter appointed me to the court.
Yeah, I'm going to share with the viewers a little bit about that appointment. I'm reading from an article back in March of '99 highlighting the incoming recognition for the Judge Advocates Association of their new honorary award, which was presented that first year. But it talks about when it was time to select a chief judge in 1980. The selection process was a love-in for the 14-person selection committee. And an article by Jonathan Lurie reads in part, an imposing figure with a sleepy smile that concealed a sharp legal intellect. Everett knows both the incumbent judges at that time, and he gets along well with them. But Everett possesses more than experience and expertise, and he goes in to talking about some of that previous experience. Maybe he was writing the book back in '56. It was the involvement with the court back in '53. And for a few years before going back to Duke Law School. But it was that, and he later writes, under his leadership, the court reached out to Judge Advocate Generals, emphasizing a commonality of justice rather than a clash of jurisdictions. Thus, his appointment signaled both the end of an era and the advent of a new chapter in the court's history. I don't think I understood the magnitude until a guest was in here a few months ago, Tommy Britton, a local attorney, who's a JAG officer as well, and he, after the interview, connected the two of us. It was exciting hearing him talk about the impact you had on the military courts and on the military itself.
Well, at that particular time, just before I was appointed, the court had not been getting along very well with the Department of Defense. And there was sort of a battle going on between the chief judge of the court on the one hand and the general counsel of DOD on the other. And in fact, the general counsel had recommended the court be eliminated. It got that serious. And at the time I was appointed, and I was appointed to fill the vacancy created by the departure of a very famous judge here in South Carolina, Matthew Perry.
Oh, yeah.
They've got a courthouse named for him up in Columbia. Anyway, Matt Perry had been on the court and then came back to South Carolina to be a district judge. But at the time that I was appointed, in addition between the battle between DOD and the chief judge had a very different philosophy, apparently, than the other judge. It was a three-judge court then. And there were two of them that couldn't agree. They didn't even bother, were not even having hearings because they were waiting for somebody else to come and sort of resolve some of the issues. So there were enough problems. It made it a real challenge. Fortunately, I was on good terms with both the judges. One of the other interesting things was at that time, but this is no longer true, the president had the authority to designate somebody as the chief judge. As, for example, when I came on, right at that same time, I not only became a judge, but the chief judge, because President Carter designated it that way. the chief judge became the junior judge, which is a little difficult, sort of to adapt to. But anyway, that was the situation. That's been changed so that now the chief judge serves for 5 years. It's based on seniority. So there I was as a new judge and also the new chief judge. And the then chief judge had been, in a sense, demoted to being associate judge. It was a challenging period. And the services were having a terrible time then because of the drug war. The caseload of the court had been in the, say, range of about 1,600 a year at the time I arrived. And then, lo and behold, it got up to about 3,400. And some other things happened that were interesting. One of the judges who was there, when I arrived, retired. The second judge, who had been the chief judge before I arrived, had some health problems, and he ultimately was given a medical retirement. Well, to fill one of the vacancies, there was appointed a wonderful judge. He'd been a trial court judge here in South Carolina. His name was Walter Cox, of a very distinguished family, very well-known family in South Carolina. I think his dad had been president of Clemson, and Walter had been a trial judge. I think he also had been an outstanding football player for the Clemson Tigers early on.
That's right.
But in any event, there were just the two of us for about a year and a half. And the caseload jumps up from about 1,500 to 3,400, somewhere in there. And we're waiting for a third judge, of course. But meanwhile, fortunately, we had enough similarity in judicial philosophy. We were able to get a lot of cases out of the way. And we worked hard at it and kept things relatively current. And Walter was a great guy to work with. He later became chief judge, retired from the court. He's now a partner or of counsel with the Nelson Mullins firm down in Charleston.
Sure.
Yeah. But it was a very interesting time. For example, the Supreme Court in 1969 had handed down a decision saying that in the United States, a service member can be tried for a crime under the Uniform Code if the crime is service-connected. Overseas, he can be tried for anything, whether or not it was service-connected. Well, what does it mean to be service-connected? For example, what if I possess drugs? If I possess it on base, service-connected, but what if I go off-post about 100 yards to conduct a drug deal or to puff cocaine, marijuana, whatever, then it was not service-connected according to some of the decisions. Very confusing situation. And ultimately, the Supreme Court in 1987, I think it was, after I'd been on the court about 7 years, reversed the earlier case and said, if you're in the military, it makes no difference whether what you do is service-connected or not, whether the military can try you.
Mm-hmm.
So that eliminated a lot of questions and a lot of issues. It eliminated questions as to whether someone who raped a woman off post could be tried by court-martial or not, and so forth.
Wow, yeah.
So a lot of exciting issues.
We got a minute, and it was a good segue. I'm so glad you mentioned Walter Cox, who now lives in Charleston. He had a couple of great quotes. He was beaming with admiration. He said, I was once going to write a bio about him, about you, but I found it was too daunting of a task. He then goes on to say nobody is more qualified in military justice than he is. He is the smartest man I've ever known. He has never done anything by accident. Any feelings about Walter's?
Obviously, he's a very good friend.
Yeah, that's right. He's making all that.
I'd love to think I could live up to some of that.
I know he talks about what's most important is your heart of gold, and he really hits home a good vein there. Dad, how would you feel about coming back tomorrow to spend a little time with us to wrap up more or less the week and to help highlight some of your service there at Duke Law School as well as in your legal practice?
I'd be delighted.
Great.
It's fun to be interviewed by my son.
Yeah, it's tough, Dad. It's tough. Stay tuned to more Carolina People with Robinson Everett coming up next. If you've been with us the last 30 minutes, you'd know it's not only that understanding of military law, national security law, criminal law, or even constitutional law that's helped him be just that much better. An attorney, as well as a judge, as well as a law professor. He's made the commitment to all those professions. He continues to make the commitment, and he'll do it for a heck of a long time. Robinson Oscar Everett.